Hello, everyone. Welcome to another interesting session of law with me, CA Preeti Agarwal. Let's learn law like never before. So, students, up till now, we have discussed what is an offer, what are the essentials of offer. We also studied the classification of offer. Let us now discuss the rules of offer. It's going to be a very lengthy session. So, you can sit with a bottle of water, some snacks, because we are going to discuss all the rules in today's session itself. If you feel that you need a break, you can stop the video anytime you want. Your views will not be affected by that. So take a break whenever you want. You can continue watching. You can pick up from where you left. So let us discuss the rules of offer. What kind of questions can be asked from this? Generally case-based questions. I don't think they will ask you a theory question and ask you to write all the rules of offer. So you can expect a case-based question on this. Let us discuss each rule separately. Basically, the head point will give you an idea of what the rule is about. There are many case laws that we are going to discuss over here. All the case laws are properly mentioned in theory form as well as arrow format. Okay. Now, the first rule is that offer must be capable of creating a legal relation. What is the equation of offer? What is the equation of contract? Do you remember the equation of contract? We had discussed this in the first lecture. Contract is offer plus acceptance plus enforceability. Your offer must be such that it creates legal relation. What kind of offer? In what kind of offer do we presume that there is intention to create legal relation? Business, commercial, or social, domestic? In case of business or commercial transactions, we assume that the parties intend to create legal relation. But in case of social or domestic, there's no such presumption. We had discussed that contracts between husband, wife, family members, we don't intend that parties will want to file a case. Yeah, you can add enforceability separately, that we had already discussed. You can add enforceability separately. But we presume that it's your personal matter. Please solve it, because each and every promise between family members, husband, wife, if it becomes a contract, then the courts will be busy in solving small squabbles. Yes. So husband promised the wife that he will take her for a movie, and he comes late from office. Wife wants to file a case just because the promise was broken. We cannot treat each and every promise like a contract. So we presume that there is no intention to create legal relation. If you want, you can show intention. You can get it in writing. You can get it registered. You can mention that if the contract is not performed, if your promise is not fulfilled, I will file a case. All that is possible. But prima facie means first impression. We assume that parties do not intend to create legal relation. Your offer must be such that it creates legal relation. Now, let's say, for example, let me give you an example to understand this concept better. Let's say, for example, that X offered to sell his flat to Y for 50 lakhs. Will this be a valid offer? Yes, ma'am, he intends to create a legal relation. It's a commercial transaction. It's a business transaction. X gave the flat, but Y did not pay money. X can file a case. It is understood. So this is a valid offer because it creates legal relation or relationship. It creates legal relationship. Another example. X and Y, they are neighbors. One evening, over a couple of drinks, X told Y, "You are such a good neighbor that I will sell my flat worth 5 crores to you just for 5 lakhs. You're such a good neighbor. You have always taken care of me. You have always helped me. You are such a good neighbor that I will sell my house worth 5 crores just for rupees 5 lakhs. Y also knows that X is not in his senses and he's joking. He says, yeah, okay, I will buy your flat. Is this a valid offer? Is it a valid acceptance? Will this create a valid contract? This is not a valid acceptance. X did not give an offer with the intention that it should be accepted. And yes, they are of unsound mind. Again, it will not create a valid contract. But it was given very casually. That is not a valid offer. So this is not a valid offer because we never had intention to create legal relation. There is no intention to create legal relation. You can also write that in case of business or commercial transactions, or you can write in case of business or commercial offer, we assume that there is intention to create legal relation. When this offer is accepted, it will create a valid contract. But in case of social or domestic agreement or domestic transaction, or in case of social offer, we assume that there is no intention to create legal relation. This kind of offer, even if it is accepted, will not create a valid contract. Even if it is accepted, it will not create a valid contract. Let us continue. I hope you have written all this in your notebook. Yes, let us continue. Offer must be such that on acceptance, it should give rise to legal relationship. If the offer does not create legal relation, it is not considered as a valid offer. X offers to sell his house to Y for 50 lakhs. He wants it to be accepted by Y. It's a valid contract. X invites Y for a cup of tea, and if Y does not turn up, can X take action? This is a social agreement. It's a social agreement. We assume that parties don't intend to sue each other. This is not a valid offer. It's not a valid offer because it is just a social agreement, and we assume that parties do not intend to create legal relation. Offer must be communicated. Yes. What is the definition of offer? What is the definition of offer? We had discussed it in section 2, clause A. When one person signifies to another, what is the meaning of signifies? Communicates. How will he communicate the offer? What are the different modes of communication? You can either give it orally or in writing. You can write an email, letter, fax, or you can give an offer face to face. Sometimes it is implied from the action or conduct, like bus running on a fixed route. So in some manner, offer must be communicated. Only when the other party comes to know about the offer, he can accept the offer. If there is no offer, there cannot be any acceptance, there won't be a contract. Offer must be communicated. And how will you communicate this? It can be either orally or in writing. Yes, orally or writing. Writing can be via letters, email, fax, etc. It can also be implied from the conduct. So in some manner, you need to communicate your offer to the other person. Offer cannot be accepted until it is communicated to the offeree. Offeree cannot accept the offer in ignorance. Or in other words, offeree can accept the offer only when he knows about the offer. You cannot accept the offer unless and until you know about the offer. That is so very logical. I was walking on the road. Okay, the other day I was walking on the road. My neighbor told me, "Arey, listen, I will buy your flat." I was wondering, when did I give him an offer? So how can you accept an offer in ignorance of the offer? I had not even given the offer. There cannot be acceptance. This sentence is very important for exam. An acceptance of offer in ignorance of offer. It means I was not even aware of the offer. An acceptance of offer in ignorance of offer is not acceptance. It will not create any legal right on the acceptor. Let us understand this with the help of a case law. Lalman Shukla versus Gauri Dutt. Very interesting case law. Name is very important for exam. You need to memorize the name of this case law. Lalman Shukla versus Gauri Dutt. Let us go through the facts of the case and you will pay attention to the arrow format which I have mentioned. Ma'am, do we need to learn these case laws as it is? No. You just need to know the story, the facts. You can write that in your own words. And to be very frank, in the exam, they don't even expect you to explain the facts. They just want you to write the name of the case law. But if you want to explain it, you can explain in your own words. Gauri Dutt, his nephew was missing. So he sent his Munim. Munim means accountant. Here servant means employee. Okay, not the servant who works in our house. Household work. No, not that one. Here servant means employee. Okay. Now, Gauri Dutt's nephew was missing. So he sent his servant, his employee, Lalman, in search of his missing nephew. So he said, Lalman, come here. Go and search my missing nephew. So Lalman followed the instruction of his master and went in search of the nephew. Later on, Gauri Dutt declared a reward of 501 to whoever found his nephew. Lalman found the missing nephew, brought him back. He came to know that a reward was declared. He claimed the reward. What do you think, students? Is he entitled to reward? Will he get the reward? Yeah, ma'am, he found the nephew and Gauri Dutt had informed that I will give 501 to whoever found the nephew. So yeah, he should get it. If that is your answer, wait. But if you say that, ma'am, when Lalman had gone to find the missing nephew, he was not aware of the reward. He found the nephew in ignorance of the reward. So if he was not aware of the reward, how can he claim it? What is this declaration of reward? I will give a reward of 501 to whoever finds my nephew. This is nothing but an offer. Was Lalman aware of this offer? Was he aware of the offer of reward? If you are not aware of the offer, how can you accept it? So in this case, ignorance of offer on the part of Lalman is not acceptance. How can you accept the offer when you don't know about it? In fact, over here it was concluded that when Gauri Dutt asked Lalman to go and search the missing nephew, Lalman only went and followed the instruction of his master. There was a master-servant relation between them. So when we sent Lalman in search of the missing nephew, he was merely following the instructions of the master. So in this case, there is no communication of offer. If you are not aware of the offer, how can you accept it? Gauri Dutt's nephew went missing, so he sent his Munim. Munim means accountant, so you can write over here accountant. Lalman in search of his missing nephew after Lalman left. This is very important for us. After Lalman left, Gauri Dutt announced a reward of 501 to whoever found his missing nephew. So this, after Lalman left, it helps us to understand that when Lalman went to find the missing nephew, he was not aware of the reward. Okay, so you can write it over here. After Lalman left, it implies, you can write over here. This implies that when Lalman went in search of the nephew, he was not aware of the reward. After Lalman left, then Gauri Dutt announced a reward of 501 to anyone who found the missing nephew. Lalman found the boy, brought him home. When he came to know about the reward, he sued Gauri Dutt. Ma'am, what if while he was finding the nephew, he came to know about the reward? Because see, the reward was declared after Gauri Dutt left, after Lalman left. So before he found the nephew, he knew about the reward. Even then, he is not entitled to claim the reward. Reason? You should know about the reward. You should know about the offer of the reward when you went in search of the nephew. Like we will be discussing later also, in case of finder of the goods. You should know about the reward when you find the goods. Okay. So similarly, we apply that logic here also. When we asked him to go in search of the missing nephew, go search the missing nephew. Was he aware of the reward? So when he is not aware of the reward, how can he claim it? Yes. So even though even though he came to know about the reward before he found the nephew, he is still not entitled to the reward because he did not know about the existence of the reward when he went to find the nephew. Acha, one more variation. What if when Gauri Dutt had sent him, he said that, see Lalman, if you find my nephew, I will give you a reward. Then Lalman went in search of the missing nephew. Now, is he entitled to reward if he finds the nephew? Yes, because he knew about the reward when he went in search of the nephew. So you must know about the offer before you went so here in this case, Lalman should have known about the offer when he went in search of the nephew. So did you get the variations? All right. Later, when Lalman came to know about it, he filed a suit. It was held that Lalman was not entitled to the reward because he did not know about the reward when he found the missing boy. Since he had no knowledge of the offer, he could not accept it. Okay. Offer must be certain, definite, not vague. Vague means it should not be confusing or unclear. Offer must be certain, definite, not vague. It means that the terms of the offer must be very clear. There should not be any scope for ambiguity or confusion. The terms must be clear. So you need to memorize terms. Okay, the terms of the offer must be clear. These are the keywords: clear, definite, not vague. Vague means they should not be unclear. X offers to sell a Sony, X offers to sell a Sony Bravia television to Y for 50,000 rupees. Now here, X is offering to sell which television? Sony Bravia. For how much? 50,000. All the terms are clear. It's a valid offer. We know the kind of TV. We know the price of TV. We know the brand, the make. Everything we are aware of. It's a valid offer. But what if X offers to sell 100 liters of oil to Y and X is a dealer in different kinds of oil? Do you remember we had discussed this example earlier also? X deals in coconut oil, sesame oil, sunflower oil, rice bran oil, and he offers to sell 100 liters of oil to Y. Will this be a valid offer? No, why no? Exactly. The kind of oil is not specified. A offers to sell his car to B. He says, I'm very confused. I may sell it for 5 lakhs or 6 lakhs. I have not yet decided. Will this be a valid offer? No, the amount is not certain. The price is not certain. Since the terms are unclear, this is not a valid offer. So here you can write it along with me. In the first example, the kind of oil is not specified. And in the second example, you can say the price is uncertain. The price is uncertain. Not a valid contract, not a valid offer. What if I make some variation here? What if I make some changes? X deals in only one kind of oil, coconut oil. And he offers to sell 100 liters of oil to Y. Now, will this be a valid contract? Will this be a valid offer? Yes. Since he is dealing in only one kind of oil, we are very clear about the kind of oil that he is intending, yes? So in that case, the offer will be a valid offer. If accepted, it will be a valid contract. If the terms are uncertain, they are ambiguous. What is the meaning of ambiguous? They are vague. They are unclear. The acceptance will not create a contractual relation. because we are not clear as to what exactly the parties intend to do. Sometimes the price is not clear, the oil, the type of product or the type of oil is not clear. So there is some confusion. It will not be a valid offer. Offer may, however, be conditional. Yes, we may attach certain conditions. You must have also seen big, huge ads for sale. So they will say 50% off. But in very small letters, they will put an asterisk and say terms and conditions apply. So yes, your offer may be conditional, but my only requirement is that please communicate the conditions along with the offer. If you inform us about the conditions later, then we are not bound by those terms and conditions. So can the offer be conditional? Yes, of course. But the only requirement is that the conditions must be communicated along with the offer. If we communicate the conditions later, then offeree is not bound by those terms and conditions. Let's highlight the keywords. An offerer may attach terms and conditions to the offer. But the only requirement is that the conditions must be clearly communicated along with the offer. What if we communicate those terms and conditions? Okay, we communicate them along with the offer. Offeree, you are bound to give your acceptance along with those terms and conditions, keeping in mind those terms and conditions. So your acceptance will also be for all those terms and conditions. Now let us understand this with the help of examples. Let's say that X went to a wholesaler. Have you ever purchased goods from a wholesaler? So he went to buy, let's say, notebooks. Okay, he went to buy notebooks from the wholesaler. Wholesaler said that I will sell the notebooks to you at 20 rupees per book, provided you buy minimum 50 books. So he is agreeing to sell at 20 rupees per book, provided X buys minimum 50 books. So this is one condition which he has imposed at the time of offer. Yes, I will sell the notebooks to you for 20 rupees if you buy minimum 50 books. So see, if there is a condition, you must communicate this along with the offer. If X is not aware of those conditions, because the wholesaler did not specify, he said, I want one notebook. Wholesaler is asking for 30 rupees. He said, what 30 rupees? You said 20 rupees. Arey, that is only when you buy 50. No, uncle, you did not mention that. Now I want it for 20 rupees only. Don't you think that there will be an argument? So if there are terms and conditions, then those terms and conditions must be communicated along with the offer. Otherwise, the offer is not bound by those terms and conditions. Let us discuss it with one more example. X offers to rent a house to a vegetarian family. Now, this is a very common restriction or a condition imposed in real estate, that I will sell the house only if you are a vegetarian, or I will give my house on rent to you only if you are a vegetarian. Now, see, there is a condition, but you have to communicate this along with the offer. What if X did not communicate the terms and conditions, and the family who took the house on rent started cooking non-veg? Now, can X object? No, he will not be, because he did not communicate those terms and conditions along with the offer. So yes, we need to communicate the terms and conditions along with the offer. And also, these conditions must be reasonable. What is the meaning of reasonable? The word reasonable is not defined in law. It depends upon the facts and circumstances of the case. You can write it over here. What is reasonable? This is not defined in law. It depends upon the facts and circumstances of the case. Now, the concept of conditions must be reasonable, etc., we will discuss in detail when we come to communication of offer and acceptance. So I have a case law also for you over there. So as far as this concept is concerned, just accept that whatever conditions you impose, they must be reasonable. Offer should not contain a term, the non-compliance of which amounts to acceptance. X proposes to Y, will you marry me? And if you don't reply by today evening 5 o'clock, I will assume that you have accepted my offer. Offerer cannot say that if by this time you don't accept my offer, I will assume that the offer is accepted. Offer must be communicated. Similarly, acceptance must also be communicated. Offerer cannot say that if the offer is not accepted before a certain date, he will presume that it is accepted. Just like offer must be communicated, similarly, acceptance must also be communicated. If the offeree does not reply, there is no contract. You cannot say, no, if you don't reply, I will assume that you have accepted my offer. That's not possible. Offer must not contain a term, the non-compliance of which amounts to acceptance. So a very nice example discussed here. The next rule is that offerer must communicate certain special terms or standard form of contract. See, if there are certain special terms, conditions, they must be communicated along with the offer, either before or along with the offer. If you don't communicate the terms and conditions, then the offeree is not bound by those terms. There is a very beautiful example over here. I will discuss example 2 first. Mr. X and Mrs. X, or I'll say X and Y. So X is the husband and Y is the wife. They were both enjoying a holiday in Switzerland. They had gone there for a month. So they thought that if we stay in a hotel, it is going to be very expensive. So they rented an apartment. Now the apartment owner informed them about all the terms and conditions. Okay. Apartment owner informed them about all the terms and conditions at the time of contract. That see, the mini bar is stocked fully. There are sensors. If you remove anything, you will be charged for it. Do you want me to keep it open or should I lock it? The appliances are to be used at this particular time. Please take care of your belongings. We are not responsible for any loss due to theft. Lock the doors and windows carefully before leaving. So all the terms and conditions were communicated along with the offer. X and Y, they came to their room, they kept the bags, went out for sightseeing. When they returned, the wife saw that her fur coat was missing. She said, I had hung it over here. My fur coat, very expensive fur coat, is missing. They went to the apartment owner. The apartment owner reminded them that, see, I had asked you to take care of your belongings, lock the doors and windows carefully before leaving. I am not responsible for any loss. But the husband and wife are insisting that because the theft took place in your hotel, you are liable. There was a dispute. You have to tell me, will the apartment owner be liable in this case? Absolutely not. He had properly communicated those terms and conditions at the time of offer that I am not responsible for any loss of luggage, for any loss of luggage due to theft. So in this case, because the terms and conditions were properly communicated, apartment owner is not responsible. Then who is responsible? X and Y, they shall be responsible. Let's do a variation, okay? X and Y, they approach the apartment owner. The apartment owner, at the time of contract, did not communicate any terms and conditions. He simply pasted the terms and conditions in one corner of the room and he did not even ask X and Y to go and read those terms and conditions. X and Y, they took the apartment keys from the owner. They kept their bags, went out for sightseeing. When they returned, they saw that their bags, the fur coat was missing. In this case, who will be responsible? X and Y or the apartment owner? If you say apartment owner, then your answer is correct. He is liable. He is responsible for the loss. Why? My argument over here is he had posted a small paper mentioning all those terms and conditions. He had mentioned that in the corner of the room. So shouldn't X and Y read those terms and conditions? Ma'am, but were they asked to read the terms and conditions? If the apartment owner wanted them to know about certain terms, he should have informed them, or he should have at least told them that there are terms and conditions written in the room, please go and read. Since nothing was mentioned, we assume that the terms and conditions were not properly communicated. In this case, the apartment owner will be responsible for the loss, since the terms were not properly communicated. That is why if you notice that whenever you enter a hotel which has a non-smoking room, on the door itself they write no smoking. If you have not communicated the terms and conditions to X and Y in this case, at least post the terms and conditions at a very prominent location, like the fire escape map. Have you ever observed in a hotel, the fire escape map is always pasted behind the main door? You cannot miss it, because in case of fire, you just look at that map and find the exit. So if there are terms and conditions, at least ask them to read those terms and conditions or place it at a prominent position so that they don't miss it at all. So in this case, we will assume that the terms and conditions were not properly communicated. The apartment owner will be responsible. Okay. So if there are certain terms and conditions, they must be communicated to the offeree either before or along with the offer. If they are not communicated, or maybe they are subsequently communicated, offeree is not bound by those terms and conditions. Offeree shall not be bound if the document is so printed, delivered in a state that it does not give reasonable notice on the face that it contains special terms and conditions. Yes, we agree that terms and conditions were pasted in the room, but did you inform us to go and read those terms and conditions? No, na? So if suppose there is a printed document, there are terms and conditions, at least mention on the face asterisk terms and conditions, read terms and conditions printed behind. At least draw our attention into reading those terms and conditions. If you did not, then we are not liable. Whenever a sign of 50% off is mentioned, there is always an asterisk. Terms and conditions apply. It is your responsibility to ask for the terms and conditions. Their work is over. They have put an asterisk and mentioned terms and conditions apply. It is your responsibility to go and read, find out the terms and conditions. Okay. Now, what are the standard form of contract? Have you ever given clothes for dry cleaning? You have. Okay. So on the face of the bill, yes, on the face of the bill, the dry cleaner generally mentions that we are not responsible for loss of color. We are not responsible if zari goes black. We are not responsible if the goods are not picked up in 7 days. So all these terms and conditions are printed on the face of the bill. These are standard form of contract. Standard means that bill which is printed, those terms and conditions are printed on every leaf, on every bill. He is not going to specifically write the terms and conditions. So these are like take it or leave it contracts, because these terms and conditions are already mentioned on the bill. Now, whenever we enter into a contract, see, and while we are studying Contract Act, you may feel that, ma'am, contract means it is agreed between both the parties. See, up till now, whatever contracts that I have taught you, whatever concepts I have taught you, you must have formed an impression that contract is something which is mutually agreed between both the parties, that is buyer, seller, or parties to the contract. So let's say that A and B are entering into a contract. So I think in your mind, you may have an impression that when A and B are entering into a contract, they will decide their terms and conditions. Like A says, that I will not be responsible if the goods are not picked up in 7 days' time. He says, no, no, yaar, I'm not available in 7 days. I'm going out of station. I will pick up in 10 days. All right, no problem. Then I will write that you pick up in 10 days. So many a times we get that impression that these contracts are generally customized. We form an impression that parties mutually agree upon the terms and conditions. But there are certain standard form of contracts. You cannot agree with the other party. It is either take it or leave it. Like the dry cleaner has printed many such uh, invoices or bills, and he has a proper book for it. Anyone who comes, he will only write that 10 clothes were given, sign it, write the date. But these terms and conditions, they are already printed over there. You accept it. I mean, it is understood. You either take it or you don't. Otherwise, don't give us the clothes for dry cleaning. These are my terms and conditions. So these are standard form of contracts. Let me give you another example. Have you ever gone to open a bank account? Has it ever happened that your dad has taken you along? You're not aware? Okay. So while opening a bank account, you need to fill a form. Okay? You either fill it online or you fill it on paper. But to open a bank account, you need to fill a form. Now that is a standard form. If I go to open an account, I will be given the same form. And if you go to open the account, you will also be given that form only. So now I go to ICICI. Now I'm talking about the same bank, okay? I go to ICICI Bank. You go to ICICI Bank. Your friend goes there. My relative goes there. We all want to open an account. We all will be given the same form. This is the account opening form. Now, the account opening form mentions all the terms and conditions. We never read those terms and conditions. That is another story. But it is mentioned over there. So, all these terms and conditions are already printed in that form. These are standard form of contracts. You cannot say, no, I didn't like these 4 conditions. Please exclude them in my account opening. Sir, ये ऊपर से order आया है. We don't print this form. It is standard for all the customers in all the branches. So these are standard form of contracts. Either take it or leave it. If you don't agree with these terms, don't open a bank account in our bank. Now, whenever there are standard form of contracts, the other party has to be very careful. You have to read all the terms and conditions before signing, because everything is generally written in fine print. You know, we just ignore. Our parents tell sign here, sign here, sign here, we sign it. Sometimes the bank official, he comes to open a bank account. He's telling, ma'am, you want to open a bank account? Okay, sign here, 1, 2, 3 places. Sometimes we also don't read. We simply sign, but you have to read it. You have to read the terms and conditions, because if later tomorrow some problem occurs, then you will not be able to argue because you have signed that form. So when you sign the form, it means that you have accepted all the terms and conditions. These are standard form of contracts. The special terms in case of standard form of contracts like insurance, railways, shipping, banking, account opening form, hotel, dry cleaning, I just discussed. If there are certain terms and conditions, they must be brought to the notice of the general public at the time of contract. Now, the dry cleaner on the face of the bill has clearly mentioned the terms and conditions. When you read that bill, everything is written on the face of it. He will assume that you have read the terms and conditions and also understood them. If he wants to print those terms and conditions on the back side of the bill, put an asterisk, write terms and conditions apply, or see reverse. Okay, see reverse, please turn over. At least write something which will prompt him to go and read those terms and conditions. So these terms and conditions must be brought to the notice of the customer. Let me discuss an example with you. Mr. P Mr. P reached the station at 10 o'clock in the morning, but his train was at night 10 o'clock. Okay, he reached the station at 10 in the morning, but his train was at 10 in the night. So he thought, what will I do for 12 hours? He kept his bags in the cloakroom. Cloakroom is waiting room. This is an English word. cloak means a long jacket. So in olden days, especially in England, yes, when it was very cold, so people would go and sit in these rooms because there it is a very very cold climate. So they would go into these rooms. Now these rooms are already heated, so they would remove their cloak, that jacket, and hang it on the stand. They would wait for the train. So that cloak room is basically a waiting room. Okay, so that word is derived from that concept. Now, so Mr. P, he went to the cloakroom. He kept his bags. The the cloakroom manager gave him a receipt. On the face of the receipt, it was clearly mentioned that in case of loss of baggage, we will be responsible only for $10. Now, P did not even read what was written. He just folded and kept it in his pocket. When he came back, he found that his bags were missing. He wants to claim the actual loss of $24 from them. Will he be able to? It was clearly mentioned that they will be responsible only for $10. Now, if the bags, it's not the fault of the cloakroom manager. Maybe the bags were stolen, or they were, there was an earthquake, the bags were damaged, something of that sort. If the bags were damaged, they will be responsible only for $10. It was clearly written. Why didn't you read it? So because it was clearly mentioned on the face of the bill, on the face of that instrument, you are responsible for the loss. You can recover only $10 from the owner or the manager of the cloakroom. Same example is given over here. See. Okay, same example. One of the conditions on the face, the words "see back" were printed. One of the conditions was that the railways will not be responsible for any package, loss of package exceeding £10. I assume dollars, but it's the same number. But he claimed 24, the actual value of the bag. So we assume that he was aware of the conditions. We assume that he had sufficient notice and he could recover only £10. This is very interesting. Now, let's say that you went to a foreign country. Let's say you went to Thailand, okay? You kept your bags in the cloakroom. They gave you a receipt. Now, the language is Thai. You don't know. You are not understanding what it is written over there. It is your responsibility to ask for a translation. If you don't ask for a translation, they will assume that you have understood those terms and conditions. So if the terms and conditions are printed, but you don't understand those terms and conditions, it is your duty to ask for a translation. If you don't, then we will assume that you have understood those terms and conditions and you are bound by it. Actually, even in India, if you see, there are so many languages. So sometimes the terms are written in the local language. It is your responsibility to ask for a translation. If you don't, then we will assume that you have understood those terms and conditions. Next is one super important concept. Offer must be distinguished from invitation to offer. Very frequently asked as a theory question as well as case-based question. Now, do you want to buy this pen? You can either accept or reject this immediately. It's an offer. But if I ask you, do you have 5 pieces of this pen? I'm interested in buying. Please tell me at what price are you ready to supply? Is it offer? Or is it inviting offer from the other person? It's inviting, right? It is invitation to offer. Do you want to buy this case? Okay, for 500 rupees only. You want to buy this? It's an offer. You can accept or reject it immediately. But what if I say that I want 100 pieces of it? Tell me at what price you will supply. That is nothing but an invitation to offer. We are inviting offer from the other person. So what is the difference between offer and invitation to offer? Offer is very definite. It can be accepted or rejected immediately. But invitation to offer is just a circulation of offer. In fact, it is inviting offer from the other person. So offer is very definite. It is capable of converting an intention into a contract. You can either accept or reject it immediately. If you accept it, a contract will be made. If you reject it, contract will not be made. So it is very definite. It converts. It is capable of converting an intention into contract. I want to sell this. Do you want to buy it? You can either accept or reject it immediately. But invitation to offer is just a circulation of offer. It comes before a definite offer. It is actually inviting offer from the other person. It is inviting negotiations from the other person. So let's say that I tell you I want to buy 5 pieces in this. Tell me at what price you will supply. You say, ma'am, we will give it to you for 14,000. Are Amazon is giving it for 13,000. Will you give it for 13,000? Okay, ma'am, take it. So don't you think that invitation to offer is inviting offer from the other person? In fact, we are inviting negotiations. Tell me at what price will you supply? Okay, I want 100 pieces of this. Tell me at what price will you supply? Give me a good price, huh? Ma'am, I will supply it to you for 500. Array, 500 is a retail. I'm buying 100 pieces. Okay, ma'am, 400 rupees. So negotiation is actually invitation to offer is actually inviting negotiations from the other person. Do you remember we had discussed invitation to offer earlier? Do you remember? Yes, that quotation example in standing continuous offer. Yes, standing open or continuing offer. Now, A Limited is a construction company. Okay, A Limited is a construction company. They invited tenders for cement to construct a flyover. So X, Y, Z, P, Q, R, they all offer to supply cement at a particular price. So what are we doing? We are inviting offers from the other person. This is invitation to offer. Who gave the offer? X, Y, Z, P, Q, R. We found that Z's offer was the best. He was ready to supply cement at the lowest price. So don't you think it was inviting negotiation that I want to buy cement? You tell me at what price you are ready to supply. That is nothing but an invitation to offer. Offer is actually a final expression of willingness. I want to sell this pen. You tell me whether you are ready to buy or not. So it is my final expression of willingness. Whereas invitation to offer is actually inviting offer from the other person. Offer will create an agreement upon acceptance. You can either accept or reject it immediately. But invitation to offer is not acceptance. Like if I am inviting you to give me 5 pencils, in fact, you are giving an offer. That is not acceptance. You say, ma'am, I'm ready to supply at 14,000. That's an offer. It is not acceptance. So it does not create acceptance. Then you give your offer, then I will decide whether to accept it or not. So over here, X, Y, Z, P, Q, R, they all gave an offer. We decided to accept Z's offer. Okay. So then we will decide whose offer is to be accepted. So you can write this in your notebook. Done. Okay. So offer, let's highlight, is definite. It is capable of converting an intention into a contract. Offer is the final expression of willingness by the offeree to be bound by his offer. Invitation is actually only a circulation of an offer. It comes before a definite offer. It is just to induce offer. Induce means it is just to invite offers from the other person. Where a party, without expressing his final willingness, proposes certain terms on which he is willing to negotiate. He is not making an offer. In fact, he is only inviting the other person to make the offer. So this is also invitation to offer. So the points that I have highlighted in green, they explain offer, and the points that I have highlighted in yellow, they talk about invitation to offer. So invitation is not an offer at all. It does not become an agreement upon acceptance. Now, how will I know whether it is offer or invitation? See, if you are bound immediately upon acceptance, then it's an offer. If the person who makes the statement intends to be bound by it as soon as it is accepted by the other. Do you want to buy this pen? You say, yes, I am immediately bound to sell this pen to you. That's an offer. But if the person intends to do some further act, you tell me at what price you will supply. 14,000. No, give it for 13,000. I'm negotiating. That is invitation to offer. So offer means that I am ready to be bound by it as soon as you accept it. Invitation means I am willing to negotiate. And then yes, we will wait for acceptance. One very interesting case law. Pharmaceutical Society of Great Britain versus Boots Cash Chemist Southern Limited. Very, very important for exam. You need to learn the name. You need to learn the facts. They will directly convert this case law into a question. So you have to be very thorough with it. Now, let's discuss the case law. Pharmaceutical Society of Great Britain versus Boots Cash Chemist Southern Limited. I'm writing in short form, okay? Now, Boots Cash Chemist had started a self-service system in their store. So shoppers would come, they would put medicines in their basket, go to the cashier. Okay, so they had kept all the medicines. Shopper would come, put the medicines in their basket, go to the cashier, okay, cash, and pay for it. So the Pharmaceutical Society of Great Britain said that this is against the Pharmacy and Poisons Act 1933. They said that display is offer. When the shoppers put the goods in their basket, the medicines, that is acceptance. Now, offer has been accepted. There is a contract without the supervision of a pharmacist. This is a violation. What if the shoppers put wrong medicines in their basket? It was a very valid argument. It was a very valid argument. This case went into the court of law. What do you think, students? Has Boots Cash Chemist violated the Poisons Act? Yes. Pharmacy and Poisons Act. Is there a violation? Yes. Do you think so? Now, display of goods is just an invitation to offer that I am selling these goods. If you are interested in buying, then please buy. At this stage, students normally argue with me, ma'am, how is it an invitation to offer? The price tag is mentioned. So shouldn't be an offer that I am selling the goods at this price. If you want to buy, then pick me. No, dear. Mentioning the price tag is only to attract them. That see, I am giving it to you only for 500. I am giving it to you only for 50 rupees. It is just to attract them. Display is an invitation to offer. Now, take your own example. You go to a shopping mall. Yes, I'm very sure at this stage you may be fascinated with the trolley and everything. You put so many things in your basket. 1 packet of Maggi, 2 cans of Diet Coke, 3 cans of Pepsi, 5 to 6 chocolates and chips, etc. You take it and your mom comes. Hey, what have you put? And slowly she will remove everything. Has it ever happened with you? No, this is already at home. Arey, why do you need to buy Coke? No, it's very bad for your health. Keep these chocolates back. So if display was considered to be an offer, as soon as you put it in your basket, then that was acceptance. You have to pay for it. But that never happens with us. Logically speaking, our mother puts everything back on the counter. So display is actually just an invitation to offer that we are selling these things at this price. If you are interested in buying, then please let us know. We shoppers put the goods in our basket, that is offer. Now in this case, display was not an offer. Display of goods, or you can say medicines in this case, is just an invitation to offer. The customer puts the goods in his basket, that is offer. And the cashier can either accept or reject it. So the acceptance happens at the cashier's box, till box, in his presence. So can I say that in this case, when the shoppers put medicines in their basket, this was in fact offer. When to the cashier, the acceptance, that is creation of the contract, happened in the presence of a pharmacist. There was no violation of the Pharmacy and Poisons Act. So display is only invitation to offer. The customer puts the medicines in his basket, that is offer. The acceptance, the creation of contract, the creation of contract happens in the presence of a pharmacist. So he can tell the customer, "Arey sir, you did not get the right medicines. Sir, didn't you check the date? These are all expired medicines. Wait, I will change them for you." So the point of creation of contract is at the cashier in the presence of a pharmacist. So there's no violation. Very, very important case for exam. The chemist instituted a self-service system. The goods were displayed. The tag was attached to it. The chemist would let the shoppers pick the medicines, pay for them at the till. What is the meaning of till? Cash box. Pharmaceutical Society argued that the Pharmacy and Poisons Act was violated. This is an unlawful practice. Display is offer. When the shoppers select and put the goods, that is acceptance. There is no pharmacist. We said, "Arey, you are getting everything wrong. Display is not an offer. It's just an invitation to offer." When the customer puts the goods in his basket, that is offer. Acceptance, that is creation of contract, takes place at the cashier's place in the presence of a pharmacist. There's no violation of the act. There's no violation. There is one more case law, Harvey versus Facey. Harvey versus Facey. Now, Mr. Harvey sent a telegram asking 2 questions to Facey. Question 1. Will you sell us the Bumper Hall pen? This is name of the place. Telegraph. Question 2. Telegraph the lowest cash price. So he asked 2 questions. Will you sell us the Bumper Hall pen? Telegraph the lowest cash price. Facey replied that the lowest cash price is £900. Harvey said, yes, we agree to buy the Bumper Hall pen for £900. Please send the title deed. Title deed means ownership documents. Please send the ownership documents so that we get early possession. They said, no, we'll not sell it to you. Mr. Harvey filed a case. He said that you offered to sell at £900. I accepted that. Now you're refusing to sell. It was a contract. I accepted, no? Now you're refusing to sell. It's a contract. You cannot refuse. I will file a case against you. Tell me, is there any violation? You must have read what I wrote. Now, was it an offer or was he just answering the questions? It was just answering of questions, right? Now, in this case, when Harvey asked, will you sell us the Bumper Hall pen? Telegraph the lowest cash price. He was only requesting for information. When Facey replied, that is invitation to offer, that if I sell, I'll sell it for £900. He said, all right, I will buy it for £900. In fact, that is an offer. Okay, so you are just replying, you're only answering. That's an invitation to offer. But yeah, if I sell, I'll sell for £900. Did he say, yeah, I want to sell it to you, will you buy it? No, he just answered the questions. In fact, Harvey has given him an offer. Yes, yes, I will buy it for 900 pounds. Will you sell it? It is open to Facey whether he wants to accept or reject this offer. It was held that there is no contract between the parties. First telegram was merely asking for information. Statement of the lowest cash price is invitation to offer. There is no contract to sell at the price to the persons making inquiry. Did you understand? Very good. If you don't, then you can go through the video again. Advertisement. Okay, let's discuss more examples over here. Let's discuss more examples. Now, invitation to offer. I'll write it here. Got a very bad cold. Okay, now, auction sale. I have made an announcement. Arey, everyone listen. There is an auction on Sunday. Please attend it. Is that an announcement offer? We discussed this earlier. You are so smart. This is nothing but invitation to offer. Then who gives the offer? The bidder gives the offer. Yes. The bidder gives the offer. And who accepts it? The auctioneer. He gives accept. How does he give acceptance? By striking of hammer. Very good, students. Very good. I'm so proud of you. See, we had discussed everything in detail earlier. So now when we revise it, your confidence will increase. Yes. Okay. So auction sale is also an invitation to offer. So highlight over here. Highlighted. Advertisement in inviting the intending buyers to come and make an auction. It's just an invitation. The bidder gives an offer, and when it is accepted by striking of hammer, that is acceptance. At this point, contract is made. There are so many other examples of invitation to offer. Just add over here if you have written this example. This is the time, okay, that a contract is made. Okay. Prospectus of the company. Yes, a company issues a prospectus inviting people to purchase the shares, invest in shares. Like you must have seen many IPOs, which have now, suddenly cropped up. It's a huge market for IPOs now. Through the prospectus, they are giving information about the company and inviting people, come, invest in my company. That's an invitation to offer. People apply, they fill the application form, that is offer, which will be accepted by the or rejected by the company. Allotment is acceptance. Let's write it properly. So the prospectus is actually invitation to offer. Okay, prospectus is inviting, come, invest in my company. The investors, they submit applications. That is offer. Allotment is acceptance. Okay. So prospectus is invitation to offer. Investors give the offer. The company allots, that is acceptance. It is at this point. Okay, it is at this point that a contract is made. Now the company has allotted shares to you. You will have to pay for those shares. Quotations. Tender. Do you remember the cement example? Catalog of goods, like you buy Tupperware after going through the catalog. The catalog is an invitation to offer that we are selling these goods. You tell me what you want to purchase. We customers give the offer, which is either accepted or rejected by the company. Sorry, ma'am, this is not in stock. Offer is rejected. Yes, ma'am, we will give it to you next week. Offer accepted. Menu card. It is an invitation to offer. Come, we are serving all this. We customers give the offer. Please bring these 3 items. They bring it. That is acceptance. So these are all various examples for invitation to offer. Last 2 points. Offer may be expressed. Offer may be implied. What is the meaning of expressed offer? Expressed, we discussed in types of offer. Expressed in words, oral or written. Implied, action, fact, circumstances. Give me examples of implied offer. Bus running on a fixed route. Bids, that is implied offer. Words are not used. Bidding at an auction, that's implied offer. Offer may be general, offer may be specific. Who can accept general offer? Anyone who has knowledge of the offer. Who can accept specific offer? The person to whom the offer is given. Specific offer can be accepted by that specific person only to whom the offer is given. Very good. What is general offer? Offer which is given to the public in general. Anyone who has knowledge of the offer can accept it. Specific offer means an offer which is given to a specific person. It can be accepted by that person only. Very good. So students, with this we come to an end of rules of offer. I hope you understood everything properly. You can revisit the video anytime you want, but I am very sure that all your concepts must be clear. If you have any doubts, please feel free to contact me. My mobile number is 9653447150. So you can connect with me anytime. You can ask your doubts, click a photo, write in your doubt. I would be very glad to help you. Next, we will discuss lapse of offer, and after that, the concept of offer will come to an end. Okay, so let me prepare for the next session and I will see you there.